A few items on the agenda today. I don't want to jinx it, so it should go smooth. I just did it. Oh, wow. Thinking optimistically here. I want to thank you for joining us. We have 3 items, 2 presentations from the staff, and Roberto, we can read item number 1 and 2.
Sure. Item 1, council members, is a communication from the City Planning Commission. It's a proposed ordinance that would amend various sections of the municipal code to create consistent procedures for review of projects that require multiple approvals for single development projects.
Thank you, Roberto. And I just wanted to take a moment to thank the Planning Department and Building and Safety. We had a nice event this morning, opening up the Center for Streamlining and the centralization of different departments who will hopefully make it easier for our customers and those who would want to invest in the city to develop. And so I know it went through a lot of rigorous discussion with the community folks, the stakeholders, our consultants that did. They played a very good role as stewards, but it happens because of the leadership of the department. So I want to thank you, Mr. Legrand, and the staff involved. And I keep throwing out this number, but we're at 40% short in staff. I mean, 40% of the staff is gone, and we continue to move forward, and that's a very positive statement to make in light of all of our challenges. So I just want to say congratulations to the staff for your hard work. So that being said, sir.
Good afternoon. Thank you. I'm Tanner Blackman from the Code Studies section of the Department of City Planning. It's my pleasure to present to you Council File Number 111140, an ordinance known as Multiple Approvals Procedural Revisions. This is the second proposed ordinance in our zoning code simplification efforts. It's a key implementing ordinance for the citywide development reform efforts and also for our own department's Blueprint 2011, our reorganization, and our one project, one planner strategy. This enjoys tremendous business and community support. It will result in a stable, more predictable development review process that is more transparent and comprehensible to communities and stakeholders. We'll achieve this by revising LAMC 1236 to standardize development review processes for projects requiring multiple approvals and synchronizing expiration dates for multiple approvals granted to individual development projects, and consolidating and clarifying language regarding utilization and expiration of entitlements. Further, this ordinance extends the state-mandated one-time extensions of time for subdivision approvals to add 3 years to all approval types valid from July 15th, 2008 through January 1st, 2014. There was a class of cases of approval types that were left out of how we had implemented these ordinances earlier. And then further, one last thing, and I've said this in the record at CPC, we were tracking AB 208 in the current session of the legislature while we've been developing this ordinance, and it is now sitting on the governor's desk as of July 7th, waiting to be signed. This would further extend, offer another 2 years of extension to certain maps within a given window. It passed unanimously in the legislature on July 1st, this month, and so I'd like to ask that if this body sees it fit to move this ordinance forward today, I'm kind of asking for an amending motion instructing us to revise for consistency with AB 208 and to address any other comments we've received so far. Thank you.
So if Joe Citizen just heard you and someone were to ask, what did he just say? I know you gave us all the technical reasons. Mm-hmm. You did a great job of elaborating on procedure.
Mm-hmm. I haven't even started that.
But for Joe Citizen who comes in, does this mean now that what they paid in fees, what they paid in trying to develop a parcel of land, that they will get that extension? Can you just imagine you're talking to your neighbor and they ask you, what did you do today?
Okay, first off, bottom line, this ordinance will result in a more stable, more predictable development review process in the city of Los Angeles, and one that will be more transparent and comprehensible to stakeholders, communities, developers alike. That's what this ordinance does.
And because it eliminates redundancies.
Yes, efficiency gains, things will process through our system better. It'll synchronize the expiration of those entitlements on complex projects, And with the specific extensions part, that's a one-time extension of time that we're implementing state law and giving it to all approval types where we left some out before.
Great, Mr. Tan. Believe me, the planners and technicians and engineers understood you.
Cheers.
I'm thinking of Joe Citizen, and thank you for that.
Thank you.
All right. Any questions from my colleagues on this? Any comments? All right, so we will request that the city attorney prepare the ordinance, and it's ready for that. But before we do our final act, we have several cards in front of us. Just want to let you know what the direction of the committee is going to be. So that being said, we have cards from Stuart Waldman, John Bowman, Will Wright, Doug Haynes. Come on up.
Good afternoon. I'm Stuart Waldman, President of the Valley Industry and Commerce Association, VICA. We represent over 360 members that have created more than 100,000 jobs in the city of Los Angeles. On behalf of VICA, I wish to thank the Planning Department for their exceptional work in revising the zoning code. This draft ordinance offers effective and logical solutions to the business community's concerns over their ineffectually vague current multiple approvals procedure. By establishing a uniform procedure for the consideration of projects and a process for developer appeal, the city will encourage the investment in infrastructure necessary for its economic recovery. We are particularly satisfied that the revised process organizes application review around a decision maker rather than case type, and that the ordinance clearly outlines a hierarchy of decision makers. The technical revisions of defining vague terms also create essential consistency in terminology across all discretionary permit case types. We strongly urge the council and the committee to approve the draft ordinance. An accessible, transparent, and sensible zoning code will serve the city and the business community well. Thank you.
Thank you, sir. John Bowman.
Good afternoon, Chairman Reyes, members of the committee. My name is John Bowman with Elkins Colt Weintraub. For many years now, I have represented Joe Citizen in the city's planning and zoning entitlement process, and I speak today really to, number one, express support for the proposed ordinance before you, and also to commend staff for doing a really yeoman's job in harmonizing, synchronizing, and clarifying a lot of very complex and sometimes conflicting code provisions. I would also like to make reference to a letter that my office submitted yesterday, wherein we do propose some further modifications to some of the changes, modifications that we believe will add further clarity and certainty to some of these provisions. I've discussed some of these changes with staff. My understanding is that staff does agree with at least some of them. So we would ask that if there is going to be an amending motion, that also include direction to staff to include some of these other changes that staff may concur with that would further improve the proposed ordinance.
Thank you. And,
Thank you very much.
Mr. Bowman, one question. In reviewing the material, one of the concerns I have is making sure that there's public hearing, public process in this discussion. Has that been compromised in any way?
It has not. The same amount of public participation would be provided. This ordinance, I think, really works more at the back end after the discretionary decisions have been made with full participation by the public, and it really has to do more with expiration, effectuation, the technical aspects after the decisions have been made.
Thank you, sir.
Thank you.
Will Wright and Doug Haynes.
Good afternoon. My name is Will Wright. Work for the American Institute of Architects. We're here to support not only the result, but the process. This was an outstanding process, and I'm not a technical guy. I don't know any of the language here, and I was brought up to speed, so I really appreciate the Planning Department's effort to educate me. We do have our letter of support that I have in front of you, and I sort of want to highlight one feature of our support is this will help save the city money. By streamlining the process, by cutting back on redundancies, by enabling the planners to focus on planning as opposed to deciphering and going back and forth with all the Byzantine language, we're really doing a service not only to the developers, to the business community, to the cultural community, but to the city itself and its budget. And to that degree, we really want to advocate, and you'll hear more from AIA on this, is more additional resources to the planning department to fund comprehensive zoning reform. I think it will more than pay for itself. Thank you.
Thank you, sir. Doug Haynes. And we'll have David Thompson.
Hi, my name is Doug Haynes. I'm with the East Hollywood Neighborhood Council. And actually, I will respond to your question about public hearings and public participation, because the one item that's really missing from this ordinance is an opportunity to address the problems with the SB 1818 density ordinance. And a year ago, Councilman Kikorian, you put in a motion, and Councilman Weiser, you've also put in motions to address the problems with that ordinance. And I'll read part of that. It says, since its enactment into law on April 15, 2008, the city's SB 1818 density bonus ordinance has caused too many impacts in our neighborhoods at the expense of too little affordable housing. In fact, too many instances have resulted in these development projects resulting in the loss of affordable housing. And you put in 3 items that you'd like to see. Number 1 is require all density bonus applications to provide written financial proof that any incentive is financially necessary, to expand the notification radius for all density bonus cases to include all those who are within 500 feet, and number 3, to allow any interested stakeholder to appeal a density bonus determination and not exclusively abutting property owners and occupants. And you stated in here, to miss an opportunity to fix our implementing ordinance is not acceptable. And here's that opportunity right now. I understand that this is about consistency with multiple approvals, but you do touch upon the density bonus ordinance within this proposed ordinance, and it's a golden opportunity to really address these concerns. Thank you.
Thank you very much. Mr. Thompson.
Good afternoon, David Thompson, Senior Project Manager with Latham & Watkins. We are here and very supportive of what the Planning Department has done. Tanner Blackman and Alan Bell have really done a terrific job with this. We really think that this ordinance will help bring the kind of stability and clarity that's needed to the process to allow complex projects to move forward and know that they have certainty that all of the components of a project, so this is very project-focused ordinance, will allow that project to go forward and not be held back by any one element of it. We also think that the component that extends the life of existing that Tanner talked about for another 3 years is really important in this economy to keep those projects alive and allow the job development that comes with it. We too have submitted a letter that's before you with a couple of minor technical corrections that we think would help improve it just a little bit more, primarily having to do with the stay that occurs during litigation or while something's being considered by the Coastal Commission. So we would ask that your support of the ordinance with some of those technical corrections.
Thank you, sir. One question?
So in your letter, you are asking that there not be notification?
No, what we are saying in our suggested corrections are that the city is already going to receive notice if there is any litigation that's occurring through the city attorney's office, so that a requirement that the applicant submit notification within a tightly defined 10-day period actually could end up being detrimental to the project. So we think a minor correction there would help improve the ordinance a little bit.
Okay, thank you.
Thank you, sir. We have Joe Miller, Jack Allen, and then Ann Gwynn. Good afternoon, sir.
Good afternoon, Mr. Chair, members of the committee. My name is Joel Miller with SOMAS. My remarks will be brief. First, I'd like to commend Tanner Blackman, Tom Rothman, Alan Bell, and the rest of the city planning staff for advancing these amendments. Secondly, I'd like to point out that no one particular interest group benefits from these amendments. We all do. These amendments provide clarity where clarity, unfortunately, is lacking. So I would encourage the committee to move this proposal on to the full city council. Thank you.
Thank you, Joe. Jack Allen? Good afternoon, sir.
Thank you for coming. I'm Jack Allen, representing the Palisades Preservation Association, and also the Pacific Palisades Community Council. We support the streamlining of the multiple approvals project, but we oppose the granting of the extensions, the extending of the extensions that are not mandated by state law, because we believe that the extensions are contrary to public policy and may wind up harming the economic recovery for the city. Public policy has always called for the expediting of projects. The expedition, putting time pressure on applicants, gets housing built, commercial and other projects that generate revenue and jobs built, and to streamline the approval process is done in this proposed ordinance, and then extend the expiration dates is counterproductive. And I've set forth the reasons in detail in here. Well, the other reason we think this ordinance should be completely recirculated, because the title of the ordinance and the project description that was circulated indicates that all these time extensions are mandated by state law, and several of them are not. And it misled the public into thinking that this ordinance was required by state law. We also feel that the ordinance should be subjected to further environmental review, because it applies retroactively to projects that have already gone through the environmental process, and which, if changes have happened in the conditions surrounding these projects, if they're automatically granted extensions, get no review by the city. And therefore, for this reason, we think this has to be recirculated, and we would like these extensions, that automatic extensions should not be granted where they're not required by state law. Thank you.
Thank you, Mr. Allen. Ann Gwynn? And then Sandy Sanchez.
Good afternoon, Ann Wynn with the Central City Association.
Good afternoon.
I am going to echo everyone's good praises, so I will keep my comments very short today. We'd like to applaud City Planning's proactive code simplification efforts. Tanner, Tom, Alan, Michael, they've all been an absolute pleasure to work with. These approvals will benefit both the applicants and our communities by establishing a clear and transparent review system, allowing all stakeholders to accurately assess a project as a whole. Just as important, the amendments will show potential investors that Los Angeles understands the importance of certainty and will take the necessary steps to create it. This is a very much appreciated effort, and we would love for you to support it this afternoon. Thank you.
Thank you. Sanchez and Jim Rice, I believe.
Good afternoon.
Good afternoon.
I'm Sandy Sanchez, Government Affairs Director for the Building Industry Association. On behalf of the members who make up the BIA, thank you for the opportunity to comment on this proposed amendment. This change will enable much-needed automatic 3-year approvals and allow for several multiple project approval deadlines to align together, making it easier for development community to manage deadlines and expirations, while also allowing the community to understand when projects have lapsed. These significant changes, especially in this economic environment, will provide a greater entitlement security and certainty, encourage development, aid with the difficulties of achieving and obtaining financing, provide for a more realistic time frame to complete development, and most importantly, save the City of Los Angeles on staff redundancies. I want to commend city staff for their work on this multiple approvals procedural revisions and providing this much needed change to the zoning code, and strongly encourage approving this ordinance.
Thank you, ma'am.
Good afternoon, council members. My name is Jim Reese. I'm with the land use consulting firm of Craig Lawson and Company, and I too am here to support this process in this ordinance. It's a huge win for many of the applicants I work for, and I also think for the community, because it does create that consistency. With that support in mind, we also have submitted letters to the city, which I'm presenting another copy today to you, where we are requesting some minor tweaks to the ordinance to work with staff. Staff has indicated to us as well that many of these are acceptable. So without wasting any more of your time, I urge you to approve this ordinance, move it forward, and also urge staff to work with us and other stakeholders on some of these minor tweaks.
Thank you. Thank you very much, sir. Mr. Chan, if you don't mind, just come to the microphone. I want to make sure we're thorough in our discussion here. The assertions made by some of the speakers in that the extensions that have been contemplated or being asserted, that does fall within our purview as a municipality?
So, state law in the last couple of years have extended one-time subdivision maps. Subdivision maps are under the purview of the California Subdivision Map Act, which we implement locally. When we decided on how to implement this law locally, we extended that benefit of the extension to related entitlements for those subdivisions because they're part of the project that makes the whole development to be built. There's a weird question of relatedness that sometimes through the process one realizes they also had to file for this. It wasn't part of the original bundle. Is it related or not? That was part of our problem. And then also, since the intent of state law is to give this extension because of dire economic circumstances, that we think it would be with the intent of state law to extend that benefit to all project types, ones that didn't benefit because they didn't have a related subdivision.
So that gives us the flexibility.
We have the flexibility to create our own recession window independent of state law if we want to. In the 90s, several cities, without any benefit of state law, made their own sort of extension for a window of time. It's completely within our power, as I understand it.
Roush?
Yeah, there's Charlie Roush, Planning Department staff. There's also an additional one, which currently conditional use permits, variances, and various other quasi-judicial actions have a 2-year term plus 1-year extension, which is applied for by the applicant. We are similar to what we did a few years ago with zone changes, where it used to be 3 years plus 3 1-year extensions. We're just making it a flat 3-year term so the time extension is not required. It's a problem for us. It takes up staff time. There's a small fee involved in it. But the most important thing is oftentimes projects are sold. The original applicant doesn't tell the new owner that the project has to be extended for an additional year, and we have numerous cases where people run out of time because they were not informed by the previous owner that they had to extend the case. So this takes care of that problem.
Thank you, Mr. Rouse. Colleagues, any questions for the staff or any comments on this?
How does this fit into the other larger reforms in our development process? We had that presentation to this committee maybe 2-3 weeks ago, and is this included in there? And I didn't, in that plan, I didn't see anything coming to us this soon. So this is great, but I just want to know how are we connecting and how does this fit in with the overall reform of the development process?
Mike LeGrand for the record. This process to reform the zoning code started about 2 to 3 years ago. And the staff work and the public outreach we did, we went to numerous neighborhood councils, also the development community and land use experts to get their input, and that's what's now coming before you. There is a mention in the strategic plan for development reform of this because it's something that's going to come out in the first year because we're already so far along in this, but this was started well prior to the consultants getting on board and working with us on development reform. This goes back a couple of years. And one thing I think that's important to mention, a lot of the neighborhood groups that negotiate conditions with your council offices, for example, maybe there's a pocket park included, or maybe they're going to do some kind of streetscape improvements, or there's certain types, no balconies on the rear of the project. Those are negotiated and discussed at length over many meetings. When those entitlements expire and the new applicant comes in, or the same applicant, and reapplies for those, a lot of those people assume that project has already been negotiated and vetted through their community. This allows those conditions that are posed on those projects to remain in place rather than having to go back and spend the community's precious time on getting these types of benefits added to these projects that they see that make their quality of life improve when these come in their neighborhoods. So it's really a double-edged sword. It really does help the communities who get involved and spend their time participating in our process, and also the development community who's gone through that process to give them both certainties that what they approve will get built.
I think one of the bigger picture observations is that it's about 6 to 8 years ago we started talking about reform. The 12-2 program unfolded. we learned from those experiences. And now with the, can I put this, the slowdown of activity has given us some room to breathe with. And they've brought in neighborhood council representatives, as was indicated today, the business interest groups, the neighborhood interest groups, and to formulate a process where they had these discussions is becoming evident in how these products are being produced. So again, my hat goes off to the staff and being able to bring in that. So we're seeing it happen in different layers and different levels from an organizational point of view, because the reality is the reorg, geographic focus, the focus on community plans, now the codes, now looking at the TODs, looking at the subways and the light rail lines. We see this whole process unfolding that speaks to hopefully enhance confidence and clarity in the process.
And that's definitely our goal, Councilman.
Thank you. Any other questions, Councilmember? So if given the input by the staff and public comments, I'd like to request that the city attorney prepare the ordinance with all the comments in place. Anything else we should add, Roberto?
I think you want to read into the record that you're agreeable to the amendments that were suggested as far as the extensions for the track maps that were mentioned as part of AB 208.
Okay.
And the letter from Latham, and I think there was another comment that someone made.
And we'll let the staff assess it.
Sure.
Right.
Yeah, and I didn't get a copy of Mr. Bowman's letter, so I want to make sure, does staff have those, and just to make that clear. You have those? Okay, because I didn't get a copy. But and the direction is to assess it, right? I mean,
right. I'm not saying implement. I'm saying assess and make it part of the discussion, and we'll hear feedback once it comes back to the committee as to what was, how it was treated, so we can understand the direction of this ordinance before it gets to the full floor. Okay. All right. So, item number 2, Roberto.
Item 2 is again a report from the Planning Commission. It's a proposed ordinance that would regulate on-site shopping cart in the city by creating a containment system for new stores and major remodels that provide 6 or more shopping carts to the customers of those stores.
Please.
Good afternoon. Gabriela Juarez, City Planning Department. Abandoned shopping carts are a source of blight throughout the city of Los Angeles. Abandoned shopping carts can obstruct pedestrian and vehicular traffic in the public right-of-way, creating hazards to the health and safety of the general public. Furthermore, the proposed on-site shopping cart containment ordinance responds to a motion, Council File 08-2070, instructing the City Planning Department to develop a shopping cart containment program similar to that of the City of Glendale, California's model that mandates shopping cart containment and retention on site. The proposed ordinance creates new development standards that requires on-site shopping cart containment for all new stores and major remodels that provide 6 or more shopping carts to their patrons. The proposed ordinance requires merchants who operate a business that provides 6 or more to any on-site shopping cart to use any on-site shopping cart containment method of their choice. We're not here to dictate the method, only that they implement one. The city is limited by the state's legislature to address abandoned shopping carts. Specifically, the state law prohibits cities from removing abandoned shopping carts from the street for 24 hours before removing them, so as to allow stores the opportunity to collect the carts. According to the state law, city staff is required to monitor and watch each individual cart for a minimum of 24 hours. The direct costs to the city involved in following these regulations have been too onerous to document on a citywide basis. Due to the state's requirement, 80 to 90% of abandoned shopping carts are not collected by city staff and remain on the street. Furthermore, state law requires that each incident of illegal possession of each shopping cart then be treated separately. Store managers would be required to go to court on a daily basis to deal with each individual incident, leaving their stores unattended, and the manager would be required to bring charges against one of their store's customers. For these reasons, few citations are written for shopping cart removal under the state regulation, as the city attorney's office is unable to prosecute them. This is one of two steps in the full program's approach. We are first asking to implement this ordinance for new and major remodels through the Department of Planning and their land use zoning. And the second step would be to address existing stores with an annual inspection program through coordination of Public Works, Bureau of Street Services, and Bureau of Sanitation. This would require a fee study to analyze the number of merchants that would be participating and the operating costs involved to staff. The second part of actual program implementation would then be run through coordination of Public Works, Bureau of Sanitation, and Bureau of Street Services.
What I appreciate the amount of work that's gone into this. There's been a controversy in the city for some time, and I think different motions have been made, and implementation and enforcement has been always difficult. So hopefully this will give us another run at correcting a problem in a large part of our city. And as I mentioned before in another conversation, one of the concerns I have is the motivation for having shopping carts in the street, especially when, and it's unfortunate, our economic times has created a whole sub-economy in terms of how people use the shopping carts for recycling products, and how recycling centers themselves benefit from having the shopping carts piled up on the sides of the streets, along the corridor, and then all the attractive nuisance that occurs as a result of certain folks whose behavior is, I think, thwarted by different addictions that create a lot of these problems. That being said, looking at how we would enforce and hold the recycling centers accountable for having carts on their property, is that something that can be done at this run of the ordinance, or is it something that we would have to amend and research and come back later? Can you give me a perspective on that?
Sure. The land use ordinance before you today probably would not be able to accompany that request. However, as the second step of this program is implemented, it could be encapsulated as part of the penalties involved and the citations that are issued through both sanitation and street services as part of their regular sweeps.
So if I play this out, there's a recycling center who has, let's say, 8 shopping carts in its property. There's 5 or 6 outside on the sidewalk. There's 2 or 3 more within blocks. They would be cited for the carts on site, or is there enough of a nexus to cite them for what's on the sidewalk?
The requirements of the program would have each shopping cart labeled for its ownership. So if the shopping carts belong to a different store, the store would be cited, but also we could look into possibilities of how to penalize the on-site existence of recycling centers receiving them. That's a nexus that would need to be made through a fee study and the operational costs as the second part of this program.
Okay. Charlie, do you have anything else to want?
I think Gabriella pretty well said it, but I think you're probably looking at some criminal penalties for doing this, and then that would take a separate ordinance, because we're really amending the zoning code here. That's either in the criminal code or the administrative code. So I think in the follow-up ordinance, that would probably be the best place to place.
So the best approach, and I'll ask Roberto and Charlie and Gabriela, does it require another motion, or is it directed for an amendment?
I think the report is pretty clear that what's before you, this is a draft ordinance that will apply to new stores and those that are facing major remodels. The second component of the report will be existing stores, and they're asking for the feasibility study that I believe the Department of Sanitation will do. So that's already part of the report.
And the issue of the recycling centers, where would that go? How can we move?
Right, and I think you're referring not to, like, the the mobile things at a Smart and Final or Ralph's, local Ralph's, but the standalone recycling centers.
Exactly, the independence.
Yeah. And then the other thing is who's going to cite them? I mean, the police driving by, seeing it, or Bureau of Sanitation or whatnot. So I think you have to look at it a little more carefully on this as to who would start the process.
What instruction for me now to look into it, would that suffice to give us some traction to get an end product?
I think you could separate it. The first direction would be to refer this issue to the city attorney to do the ordinance that would apply to the new stores, and the second direction would be for the existing stores to instruct the Bureau of Sanitation to complete the feasibility study and find out what those fees would be and who would be the agency in the city that would cite them.
Okay. So any other
and add in your thing for citing off-site
correct
uses for
and recycling centers and whatnot.
Okay. Any other questions or comments for the staff, my colleagues? Councilmember?
I was wondering why the 6 shopping cart limitation was set. That seems extraordinary low number. How did that come about?
What we did was look at City of Glendale to see where their threshold was, and also to refrain from penalizing the smaller mom and pop stores from having to install some sort of containment system or hiring someone to carry groceries or purchase goods out to someone's car. It would be sometimes more than likely an undue hardship, so we didn't want to be onerous in how we went about doing this.
It's just kind of hard to imagine what that store would be that would have 5 shopping carts. You would either have a lot more than that or none. So I'm just, it seems an odd number one. Number 2, what is can you talk through a little bit what the enforcement process would be? What would be the sanctions that would come from violation of this?
We wouldn't have fleshed that out entirely because we would need to see what the fee study returns in terms of the numbers of operators that have shopping carts that would qualify for the program, and then we would have to figure out what is the most amenable structure in place to have that looked into. I think Roberto already kind of alluded to the fact that we would need to look into the various citation agencies that we have in order to do criminal enforcement or civil enforcement, depending on what would be appropriate.
And so in making that analysis, will there be some assessment of how many stores there are that operate with a certain number of shopping carts so that we can further refine that to see whether that is an appropriate number?
Right, and going to the recycling center issue, if they do happen to be a recycling center that provides shopping carts 6 or more, then they would also be part of the new and existing, and then they would, the new and major remodels. These are all things that would be looked at as part of the feasibility study, something that is outside the perimeter of what the planning department has jurisdiction to do.
Okay, thank you.
Any other questions, Councilman? No. Okay, we now go to public comment, and we have Stuart Waldman, Dennis Hathaway, and Stuart again. Okay. Fill out 2 cards. All right.
Sorry. Stuart Waldman, President of the Valley Industry and Commerce Association, VICA. While we understand the concerns of the city regarding abandoned shopping carts, the solution is not an unfunded mandate. The grocers of our city contribute immensely to the betterment of their communities, yet this ordinance seeks to discourage such investment. By requiring installation of these facilities, the ordinance will deter development by increasing costs and delays for grocers. The city should be focusing on proper measures to relieve blight rather than imposing new burdens on the business community. We look forward to alternative solutions to this issue and encourage the city to engage with stakeholders to find mutually beneficial, financially responsible solutions. Thank you.
Thank you, sir. Doug Haynes. I'm sorry, we have Dennis Hathaway. Okay. So I believe that concludes the comment cards for item number 2. So we would request the city attorney to prepare the ordinance. and that'll be the action of this committee. Number 3, I believe, has been continued for 3 weeks, so I apologize for that. That's item number 3.
And Councilman, sorry to interrupt you, but going back to number 2, as far as the existing stores issue and the feasibility study that the Bureau of Sanitation would do, you concur with that directive, right?
Yes.
Okay.
Yes. Yes.
And Mr. Chair, both of these, I was under the impression both of these were ordinances ready to be submitted to council.
No, Councilman. What's before you is the ordinance that applies to new stores and to major remodels. The issue as to existing stores, that needs a feasibility study that I believe the Bureau of Sanitation needs to prepare. So this ordinance does not apply to existing stores.
Okay, how about item number 1? Was that an ordinance that was ready to be submitted to council?
No, that was also a draft ordinance, and that's going to the city attorney to prepare it.
Okay.
Right. So number 3 has been continued for 3 weeks. I apologize for late notice. Would you like to still speak on that, Mr. Hathaway, since you're here for that?
Yes, if I could.
Yes, please.
I may not be here. I was going to speak in support of this. I also wanted to bring up something or mention something that's not directly related to this ordinance, and that is the fact that 3 years ago, the city was under siege with illegal signs. Not billboards, but the big super graphic signs covering windows, creating fire hazards, creating visual blight, basically being a terrible nuisance, and almost all of those are gone, and that's a direct result of the hard work and aggressive enforcement action by the code enforcement and the city attorney's office. And I think that we hear about the building department in the media, and we hear about bribery scandal, and we hear about the city attorney in the media, and we hear about that the city attorney has offended somebody. And I think I really like to give a hats off to the city attorney's office, the people who were involved in that effort, and the people in code enforcement, and then I hope that this body and the city council will continue to give them the tools that they need to really regulate the signage in the city. Thank you.
Thank you, sir. For the item number 4, our director's not here, but I want to thank Alan Bell for his hard work. I know you were there this afternoon as well, behind the scenes. So I appreciate your hard work, Alan. For public comments, we have Doug Haynes.
Hi, Doug Haynes on behalf of the East Hollywood Neighborhood Council. I've been asked to come down and speak to you about an issue that I've spoken about before, everyone's favorite topic, illegal marijuana dispensaries. We had a meeting several months ago that was set up by Garcetti's office that included the DEA, the City Attorney's office, Captain Murphy of Northeast Division, Councilman Weezer's office, our neighborhood council, and also Eagle Rock Neighborhood Council. And the consensus among the city attorney representative there, Asha Greenberg, and also with Councilman Weezer's office was that we need another ZA for nuisance abatement issues. And I talked to Michael Legrand about that, and he said it would cost approximately $200,000. That obviously hasn't happened. We still have a proliferation of marijuana dispensaries, and we have several opening all the time. So as a solution, as a neighborhood council member, and the other neighborhood councils are obviously as upset about this as we are, I could propose that you could ask for $1,200 from each neighborhood council. You could take it out of our budget and then get the rest from the mayor's budget or some other revenue so we can have a ZA devoted to nuisance abatement. There's got to be a solution to this. We're willing to work with you. And there are a couple matters before the State Assembly. One is AB 1300. The other is SB 847. They would help a lot, but in the meantime, we really appreciate it if the City Council could help us address the matter, and certainly the Planning Department desperately needs another ZA. Thank you.
Thank you, Mr. Haynes. Anyone else for public comment? Seeing none, this meeting is adjourned.